Welcome everyone to our webinar on using AI in U.S. and international arbitrations, which is sponsored by Mayor Brown and the Silicon Valley Arbitration and Mediation Center. My name is Jim Ferguson. I'm a Mayor Brown partner based in Chicago and New York, where I specialize in U.S. and international arbitrations. Our topic today couldn't be any more timely. The arrival of both generative AI and predictive AI has carried with it the promise of some powerful new tools for arbitration. And what I'm talking about is not simply document review and legal research, but also some exciting new possibilities such as early case assessment, generating first drafts of pleadings or witness statements or pre-hearing memoranda, or in the case of arbitrators, even creating new text and first drafts of the final award. We're going to be looking at all of these topics from three different perspectives. And to do so, as the next slide shows, we have an all-star panel. First, Svetlana Gitman will explore the use of AI by arbitral institutions. Svetlana is a division vice president at the American Arbitration Association and International Center for Dispute Resolution, where she leads all business development and outreach activities across the organization. In this role, Svetlana is responsible for the strategic expansion of the AAA ICDR dispute resolution services worldwide, highlighting the organization's experience and reputation as an industry leader in providing fair, efficient, and effective dispute resolution services. Following Svetlana's presentation on the uses of AI by arbitral institutions, Claire Morell will describe the ways in which AI can be used by the parties and their counsel. Claire is a partner with Brian Cave Leighton and Faisner in London. She's qualified in England and Wales and in New York, and has a mixed common law, civil law background. She practices international arbitration. As counsel, advocate, and arbitrator, she conducts cases in both English and French, and she has particular experience with disputes arising in the technology, crypto, cyber, and life sciences sectors, including IP disputes. After Claire has examined the ways in which AI can be used by the parties and their counsel, Benjamin Malik will describe the guidelines that have been drafted by the Silicon Valley Arbitration and Mediation Center, SVAMC, on the use of AI in arbitrations. Benjamin is an arbitrator with the chambers in New York. Having worked at Magic Circle law firms and leading institutions, he's been involved in matters involving private entities and states in commercial, investor-state, and state-to-state arbitration proceedings under the rules of virtually every leading arbitral institution. He handles cases in English, Spanish, French, German, and Romanian. Benjamin is also the chair of the SVAMC Center AI Task Force, where he and his colleagues drafted the SVAMC guidelines on the use of AI in arbitration. So we can have no better authority than Benjamin, Claire, and Svetlana on these issues from three different perspectives. Before we turn to the substance, there are a couple of housekeeping matters I need to address. First, if you have any questions, feel free to use the Q&A button in the toolbar. We will address the questions as time permits. Second, even though this is a truly global topic, and even though it has an international audience today, we are offering CLE credit to U.S. registrants. You'll find in the chat box the form that you need to complete if you want CLE credit. Among other things, you will have to enter a code, which we will show midway through the PowerPoint presentation, and then submit the form to the email address that appears at the top. So with these preliminaries out of the way, I think we're ready to begin the substance of the webinar. Our first panelist, as I indicated, is Svetlana Gitman. Svetlana, I will now turn it over to you.
And thank you, Jim, and thank you for the wonderful introductions. I'm Svetlana Getman. I'm a Division Vice President at the AAA, and my purpose for being here with you today is to tell you how the AAA ICDR embraced generative AI specifically. Innovation has not been something new to us. We've always had a culture of innovation at the AAA ICDR. Even before, the launching of ChatGPT, we had an innovation team, we had innovation coaches, we had an innovation vice president. And before the launch of ChatGPT, we created a platform to use internally for our employees to submit ideas that use technology to make the ADR process more efficient. So we've always had a culture of innovation at the AAA. Part of our new mission statement is to lead the world in providing innovative measures to prevent, mitigate, and resolve disputes fairly and efficiently. And for those of you who know our CEO and President, Bridget McCormick, she specifically made it a part of our 2024 strategic plan requires radical optionality. Generative AI requires jumping in with both feet, and that's what we did. She couldn't have been more right. That is exactly what we did. When ChatGPT launched, we asked our employees to submit ideas about how we can use generative AI to improve the ADR process. We got over 200 ideas submitted. And so we had a lot of information to work with, that 200 case use ideas. And so we tried to understand, how do these case use ideas align with our strategic mission and vision? What were the potential ADR case uses? Things like document analysis and comparison, research, document generation, and more importantly, what benefits would this bring to arbitration and dispute resolution specifically? It would reduce cost, expedite workflows, ease of use, information access. Now, what was most important to us is how does that meet our strategic objectives? It would expand the use of ADR. We'd be delivering with efficiency and agility. We'd optimize the customer experience, and we'd be setting the stage for how we are defining the future of ADR use. So before we did anything, though, we wanted to make sure that we were doing things responsibly, right? ChatGPT was new. We all heard the horror stories about Meta versus Avianca, people not reading before submitting things to the court. So what we did was, we created guidelines for our staff to experiment with how we were going to integrate generative AI. We had exploration groups. We produced guidelines for our staff and employees. We did a pilot with our arbitrators using co-counsel to see what kind of use cases we could have. We held company-wide generative AI town halls so that all of our employees can understand some of the use cases and how to use generative AI responsibly. And then we used the ideas, like I said a minute ago, that our employees submitted to think about what specific tools can we build. And before we got to building them, we did create a platform called AAA iLab, which is really a center to give guidance on the responsible use of generative AI. It has guidelines, like I mentioned earlier. It has the study, the outcome of our co-counsel pilot with the arbitrator group. So please check it out if you haven't. This is a great resource, but I know you're all trying to get to the good part, or you want me to get to the good part. What did we actually do? And so based on the ideas that were submitted to us using AI, we did come out with 3 learning pilots: the Clause Builder AI, the automated scheduling order, and the filing assistant chatbot. And let me go one by one and kind of tell you a little bit more about each one of them. So one of the biggest problems that we notice when we see clauses is poorly drafted clauses. Internally, we have a clause library of perfected clauses that, will lead to enforceable awards at the end, where the process will not have any issues. And so what we did was, this is built on ChatGPT 4. So ChatUX basically created this platform where parties can now type in the kind of clause that they're looking for. We always used to have Clause Builder, which was another free tool that we offered, but it was sort of the old school radio buttons. You went back and chose options, and then at the end, it would generate a clause for you. Well, we made it even easier where users now can come in and type in what clause they're looking for, and this will spit out a clause for users based on our perfected clause library. So that was demoed at Legal Week. It's still in beta, as you can see here, and it gets better and better every day as more people are using it. The next thing that we come up with, and this has probably been the most well-received, is the automated scheduling order. We have heard over the years that there is a time delay between when parties can have a preliminary hearing with the arbitrator to the time they actually get the scheduling order. And typically what happens during a preliminary hearing is the arbitrator's taking notes, and then they have to sort of plug in their notes into, what will be the ultimate scheduling order and then get it out to the parties. So what we did is we started recording the transcript. We piloted it first with our construction cases, the fixed fee cases, so the smaller cases, to see how it would work. We would record the transcript, upload it to also something that runs on OpenAI. It would then, in 45 seconds, generate a scheduling order. So now we're going from, maybe taking hours or a day of delay. The scheduling order is now reverted back to the arbitrator in just 45 seconds. It's been incredibly accurate. And now what we're going to do is we're going to see if we can expand it to larger cases. That's what we're doing right now, training it on more data, longer hearings to see the accuracy of it. So that right there, decreases costs right away for parties. Instead of it taking an hour or two for the arbitrator to draft the scheduling order, we've now reduced it to something as small as 45 seconds. So another great use of generative AI in arbitration. And the final thing that we're working on right now is the filing assistant chatbot. The data set as you can tell, or maybe you don't know, and I'm going to tell you right now, the key to making these 3 projects a success was that we have a quantifiable amount of data for it, that it's data we already have and it's clean data. So it's going to return good results. For the filing assistant chatbot, the data is our rule books, our guides about how to file. So from that, we've created this chatbot that we're still working on. It hasn't gone live just yet, but it's going to help those that maybe don't have an attorney, or even attorneys who aren't familiar with the arbitration process or mediation process, know how to file the data coming from our rules and our guides about filing. So again, speeding up the process and offering this. For us, this is very important because it's more than just, the arbitration process. It's an access to justice issue. We're now making arbitration or mediation available to more people by offering them these generative AI tools to help them with their filings. So that's what we're working on at the AAA right now. I'm going to pause here in case anyone has any questions, or if Jim, you have any questions before we move on to Claire.
No, nothing on my end.
Thank you.
Thank you so much, Svetlana, for giving us that perspective on how arbitral institutions are using AI. Let's turn now to a slightly different subject, which is how the parties and their counsel can use AI. Claire, I'm going to turn the floor over to you for that subject.
Thank you, James. Right. So before we actually dive into the details here, just a little intro on how parties and counsel can use AI in arbitration. I wanted to give you really an overview of the factors that one, assuming that we all counsel here just for the purpose of this presentation, the factors that one might want to consider when looking into potential use of AI. We want to look at tools. We want to look at the market, what legal tech providers are already offering. And of course, there's a lot going on in the background, and we should expect a lot of new tools in the near future, but of course in the distant future as well. So it's of course an area that is evolving very fast. So I can't talk to you about tools in particular today, as in by reference to the legal tech providers. But what I can tell you about is those other factors that I think we should all consider. We should look at data that is being used, and Svetlana already talked about that. Think about data that is being used by the tool, because AI at the end of the day is just data, and other parameters of those tools. We should think about tasks. What are the tasks that one is trying to gain efficiency on? We should look at phases of the arbitration process, and we should look at the overall context. And I think, in my view, all those things will give you information and guideline. I know Ben will talk about that later, about what you should do and how you can really tap into the benefit of AI for arbitration. So I'm going to discuss those three different factors now, talking about tasks, phases, and context. Svetlana, please. So throughout my presentation, I'm going to refer to a survey report that my firm published in the last year. So every year we do a survey at my firm on arbitration topics, and last year's topic was AI in arbitration. We had nearly 250 respondents for this survey. All of those respondents were part of the international arbitration community. And the first set of results I wanted to touch on are the tasks. There are a number of tasks for which AI can be used for, and those tasks here on the slides, by all means they're not exhaustive, but I guess it's just to give you a sense of the potential here. Lots of tasks we can use AI for. And in the first column, you see that the stats of the respondents that we interrogated on their actual use. And I wanted to focus on three tasks here, for which more than a third of respondents said that they're already using it in international arbitration. The first one is document review, no surprise there. And roughly 50% of respondents said, yes, I wouldn't object to that. Second task is translation of documents. So AI is already very much used for translating documents. I'm sure you all heard of machine learning translation. And then you just see just below real-time interpretation, which is used a bit less, but nonetheless 16% of respondents said parties already use real-time interpretation at hearing. So instead of having a human interpreter, you have a machine interpreting loudly what the witness says. And then the third task I wanted to mention is text formatting and editing. Here again, around a third of respondents said that they already use this AI for in international arbitration. So there's other ones that are a bit less used, but still already used. Legal drafting, generation of text for expert reports, generating text for awards. That's not for parties. And maybe we can finish on the last one, which I think is quite interesting, is the use of AI in international arbitration by parties to detect whether the other side is using AI. So you can use AI for your own task, but also to check if the other side is using it. 7% in this survey of respondents said that they are already using tools to detect the use of AI by other parties. So if you are using AI and not disclosing it, you should be aware of the existence of those tools. Next slide, please. I want to touch a little bit on phases, because depending on the phase of the arbitration that the party in question that is considering using AI, depending on that phase, AI might be a good idea. To use an AI tool might be a good idea. It might not be a good idea. And so let's give you some examples for those phases. James mentioned early case assessment earlier. So the use of AI by parties to undertake early case assessment. I think AI in that phase is probably the best phase, because at that time, you're not yet in a formal proceeding. You don't arguably yet have duties toward the tribunal, and you can really use AI to the best potential, to its best potential, to get the best picture you can have on a case. I'll give you an example. Sadly, there is not yet a tool that's an AI tool that does everything on a case assessment, but let me give you examples of tools that I use to perform case assessments already now. So document analysis, document review, and then you combine that with generative AI on a closed platform to check and find facts and evidence. And then you move on to AI for the purpose of legal research. Again, ideally incorporating generative AI with some kind of advice that obviously we need to check. And I wanted to, at this stage, I wanted to emphasize the fact that using AI at that stage can really provide a strong advantage for a party using AI, which is that if you have the full picture of the evidence early on, you can build your case theory then, and avoid being in a situation that evidence comes up later on that would have forced you to change your strategy. That could have been effectively a bad surprise. So in my view, this is a really good phase to use AI for. Constitution of the tribunal. The typical task at that stage is to use AI to select an arbitrator or to select an expert. Discovery, document production, we have talked about it already, and it's clearly an area where we've seen AI is already very much useful. Briefs and memorials, again here combination of fact finding and legal research, and also document generation here. And then presentation of evidence and oral advocacy. At the moment, advocates are still human, but we already use AI to present the evidence. For example, to create visual aids, to create such as videos, but also to interpret and translate, as we said. Next slide. I also want you to think about the context, because depending on the context, a tool that you want to use for a specific task could be a good idea, but actually it could not be a good idea. So, knowing the tool and how it works and knowing the phase might not be enough for counsel to decide whether AI is a good idea or not. It's just a few considerations here when assessing the context in which AI could be used by a party. Client's instructions. Have a look at client's instructions. What is your client aware that you can do or cannot do? What have you told your client? Also related to that, what does your insurance policy cover? Most professional liability insurance policy these days do not cover the use of AI. Another consideration, ethical rules. We all subject to some kind of ethical rules, depending on the bar we registered at. And those rules will give some information about duties toward the client, toward the parties on the other side, and the tribunal. So that in my mind, that forms part of the context. And then you have arbitration rules, which at the moment don't say anything about AI. The discovery protocol, perhaps that will cover some AI. Procedural order, discovery order, practice notes, and guidelines, which I know Ben will address later on. I really want, everyone to understand that the context is very important. For example, if you decide to use predictive coding, which is the use of AI to identify a document, if you use it at an early stage, for example, as part of an early case assessment, you don't need to disclose it to the other side. But if you use it to comply with an order of a tribunal, then you probably need to disclose it to the other side, just to emphasize that the context is very important. Next slide, please. I've got just a couple of minutes left, and I wanted to share some stats on the benefits of using AI. They're very obvious, but we asked questions on that in our survey, and the two most important benefits are saving time for parties and cost effectiveness for parties. And interesting finding for in-house lawyers who had also ranked very high the benefits of being able to keep tasks in-house and not outsourcing to outside counsel. So watch this space. I think in-house lawyers want to do much more work in-house when it comes to international arbitration. And AI gives them an opportunity to do that. Next slide. Now we've talked about benefits briefly, a few concerns, and I know Ben will discuss that as well in his part. But here I wanted to really go through the list very quickly, and we can have, you may have questions, and I would be very happy to answer them. But just to emphasize that actually there's still a lot of concerns around the use of AI in arbitration. For most of those concerns, around 80% of respondents were concerned. Cybersecurity, breach of confidentiality was a very high concern. Lack of transparency about the internal working of technology also scored very high. The potential bias that the data might have, and if you put in biased data in a system, what comes out is also biased. So international arbitration, independence and impartiality is important, so watch that too. AI hallucination, we've seen a lot of cases already and stories in the press. Inconsistency, lack of accountability. Next slide. Please. Deep fakes, we'll talk about that. People concerned about integrity of evidence. And then improper delegation of duties, ethical duties, and finally enforcement. Some people are concerned about enforcement of awards if AI has been used in the process. Next slide. And then more specifically on the integrity of evidence, I only have very little time left, so I wanted to focus on one finding here, which I think you will find interesting. 3% of our respondents, so more than 6 people, had been in an arbitration where the integrity of the evidence had been impacted by the use of AI. So it's quite, 3% sounds low, but actually we thought when we saw that, this is actually quite high. And also it shows that those issues around concerns and use of AI are already live. We're not talking about the future. This is already happening. So sadly, finishing on a kind of negative note here. I appreciate that. So sorry about this. I will end here, and hopefully we can have a discussion on those findings. Thank you.
Thank you, Claire. Our next topic is the guidelines that govern the use of AI in arbitration. As I mentioned, Benjamin Malik is the chair of the Silicon Valley Arbitration and Mediation Center AI Task Force, which has already drafted or issued draft guidelines on the use of AI in arbitration. For those of you who are not familiar with SVAMC, it's a nonprofit foundation that promotes efficient technology dispute resolution and technology-related business disputes, not only in Silicon Valley, not only in the US, but throughout the world. And as part of its mission, SVAMC provides educational programming and related resources such as the AI guidelines to technology companies and law firms. So with that background, Benjamin, I'm going to turn the floor over to you to discuss the SVAMC guidelines on the use of AI in arbitrations.
Perfect, James. Thank you very much. And thank you everyone that joined. Yeah, when the Avianca case came out, there was a suspicion that guidelines might need to exist in arbitration. I have to be honest, I don't think anyone thought that AI would be used to the extent it is being used today already, but we're happy it is, and we're happy that we were able to create some guidelines. First, I wanted to obviously thank the Silicon Valley Arbitration Mediation Center for allowing us to come up with these guidelines and publish them under this prestigious institution. And of course, I want to thank everyone that participated in the public survey. So what we did, and as we can move to the next slide. Thank you. So we looked at the background and the goals. I'm going to talk a little bit about the content of the guidelines and then what the next steps are, and then we'll open up Q&A not only on the guidelines, but for everybody here. Next slide, please. There we are. So background was very simple. There were several cases. It wasn't just the Avianca case. I think that was the cherry on top. There were a few cases where lawyers decided to use ChatGPT without cross-referencing, without making sure that the output was correct. In all of these cases, if not most of them, the biggest issue was hallucinations. The attorneys thought, hey, AI works great, why not? Submitted their brief, submitted their cases, and got struck down relatively hard in certain parts. So we took two cases here just to show kind of what they did. One is from the U.S. District Judge Brantley Starr of the Northern District of Texas, and Judge Vaden of the International Trade Court. We can move to the next slide. If you're interested, feel free to send us an email and I'll circulate these slides. What we did is we came up with 3 basic chapters to guide us through these guidelines and to make it more accessible. We looked at how can these guidelines be applicable to all participants, whether there are certain guidelines that are applicable only to party representatives and party themselves, and then of course guidelines for arbitrators. So we did come up with 7 principles. The first 3 would be applicable to all, which is understanding the uses, limitation, and risks of AI, which covers pretty much a lot of what Claire mentioned in those 3%, where the arbitration proceedings were impacted by the use of AI. Safeguarding confidentiality, disclosure and protection of records. And then there are 2 very specific guidelines for party representatives and parties and arbitrators, which is the duty of competence, and the respect and integrity for the proceedings on counsel and party side, as well as for the arbitrator's non-delegation and the respect for due process. Next slide, please. So we're doing this in tandem. Svetlana was kind enough to offer to do the slides, so we're playing along. So the preliminary provisions, we looked at the scope and applications of the guidelines, and the idea was to reference framework that we can use in proceedings. So ultimately, some guidelines, soft law, of course, that people can reference in their PO1 or wherever throughout the proceeding to say, hey, these will apply. We tried to set forth some best practices and principles. And as mentioned, the model clause that we would hope people want to use or do their own. Now, regarding non-derogation of applicable rules and regulation, it was really tough when we started drafting these in February of 2023. So we were very early on. But even now, rules and regulations continue coming up. The EU is working on publishing its final draft on AI law. Different countries have different AI laws. So what was important to us is to say we have some guidelines, but no matter what, we would never derogate on applicable laws and regulations wherever set. So council would have to on top of the guidelines, make sure that the law of the seat and the respective arbitration rules or ad hoc or any other laws and rules that are being used do not have any AI laws that might be impeded this way. We also looked at a very broad definition of AI, and that is because we weren't sure what type of AI this will actually address. At first, we were talking about AI. Then midway 2023, it was very specific generative AI. Now we're talking about predictive AI. So the idea is that obviously these guidelines will continue to change and move along with time. But what we're trying to get to is that these guidelines are there for the use of artificial intelligence, which means any intelligence that is out of human as of now. So if there is any part of the broad definition that people are not a big fan of or don't like particularly, just take it with a grain of salt. And I'm sure that over time, in 10 years from now, when we look back, I'm sure we'll have a much better definition of what AI is. Next slide, please. So guideline 1 and guideline 2, we were looking at 4 principles: hallucination, a black box problem, quality of data, and biases. And what was important to us is just to say, hey, there's no way at this point we can avoid hallucinations. There's no way black box problems will not occur. Neither can we control the quality of data. And as mentioned by Claire, biases are there. So if you have biased information, you're going to get biased outcome. And quite frankly, even in selecting, even in selecting arbitrators, we have seen that given prior data, especially the further back we go, there were more numbers of male arbitrators, so the outcome will be mainly male. It's not a bad thing, it's just there's a bias, and we just have to understand that there is one. So quite frankly, our first guideline was just to draw awareness of there being certain issues that we cannot control, and to have people understand what AI is and what its limitations are. Now, regarding guideline 2, and there was a big one, is confidentiality. And confidentiality, I mean, it goes on 2 ends. First of all, we need to continue keeping confidentiality, especially if there's an additional confidentiality agreement throughout the proceedings. What we were also trying to make our readers understand is that there is a significant difference between an open source AI or an open AI and a closed source AI, closed AI, and to use those wisely. In other words, if we are going to use sensitive information on an open AI, ChatGPT, for example, we need to understand that even though there might not be a direct impact on the case, that is a breach of confidentiality in itself. Whereas if we use a closed circuit or a closed AI, we can potentially put in more information if we know where that closed AI is. And just to give a few examples, several law firms have actually integrated AI into their system, where all of their arbitration proceedings and cases have been stored. So questions like, what do I do in the case of XYZ, can be typed in there, and you would get an outcome that is completely closed, only visible by the attorneys of the law firm. Yes, technically this information can be used within the closed circuit, but again, it is part of the confidentiality and can be used respectively. Next slide, please. Yeah, so disclosure. One of the biggest problems we had, and I say we were 8 people drafting these guidelines, amongst others, Marta Garcia Bell, who I actually see is present, so thank you for joining. So we were 8 people coming up with these guidelines, and one of the key aspects we could not agree on was disclosure, in the sense that do we need to disclose from the get-go, yes, we're using AI, or is that oblivious? And I mean, my personal perspective was that if we start disclosing that AI is being used, it's just going to be a pro forma that we do with every case. Like in every court case, you would say, hey, AI was used. It wouldn't tell us anything. So the question becomes whether it needs to be disclosed when there's a material threshold, or whether there needs to be a different standard. And what we came up with were two options that the parties could choose from. So when I say the parties could choose from, this is still from the draft. I am not sure what the outcome is or will be, but humor me because we have a great announcement towards the end of the slides. So we did come up with these two options, and one would be a two-pronged test saying that if the output of an AI tool is relied upon and could have materially impacted the proceedings, then it needs to be disclosed. Whereas the option B in our scenario here was that it will be disclosed on a case-by-case basis. If any one of the parties believes that AI was used, they can either ask the other party to disclose it or ask the arbitrator to request disclosure. Interestingly enough, from civil law countries, and I don't know if this has anything to do with civil law or common law backgrounds, but in civil law countries, option B was preferred versus common law countries that went with option A, a two-pronged test. I can't tell you why, but I hope that over time we'll kind of figure out the analytics of this and understand why. So as of now, disclosure was a big deal. We believe disclosure is a huge deal. As Claire mentioned, there are certain tools that will allow the parties to understand whether AI was used or not. But the question we were facing was, do we need to disclose that AI is being used? And if so, how? And we decided from the get-go that a blanket disclosure that AI is being used would really not serve any purpose. Next slide, please. So guidelines 4 is the duty of competence, and it really talks about the ethical aspects that Claire was mentioning earlier. The reason we encompassed it in duty of competence and diligence, this goes straight out of the ethical rules in the US, for example. But there are different countries that this will apply to, different proceedings, different laws. So not every country has the same standard of ethical duty, and not every ethical duty is the same. So all we're trying to say is just be mindful of the fact that as attorneys, as counsel, there is still an obligation to be diligent. There is still an obligation to look through the documents that you're submitting. And even if you're not familiar with the hallucinations, you believe it's hallucinated or not, give it another go. Once it's submitted and the attorney has signed, it is a submission by the attorney. So we can blame AI on a million things, but quite frankly, AI would never make a submission on its own, or not yet. We haven't come across one yet. It would always go through an actual person. And all we're saying is just be mindful of the fact that there is a duty to make sure everything is fine. Not only competent in the sense that making sure the output is right, but also diligence. We got to also represent the client properly. So if we only base ourselves on the arguments that AI makes, we might actually miss out on a lot of material we have saved in our experiences, right, over the last several months, in our brain, in our colleagues, and so forth. Guideline 5 talks about the integrity. So all we're saying is whether experts shall use AI or not, just be mindful of the fact that the integrity should not be at stake. If we can move to the next slide. Perfect. And then here we go into the guideline 6, which is a non-delegation of personal mandate. This talks strictly about the arbitrator. And the biggest question was, is the arbitrator allowed from the get-go to use AI in any sorts of drafting? And we looked at it from different points of views. Quite frankly, nowadays we do use tribunal secretaries. We do disclose the use of tribunal secretaries. So we started with the premise that, disclosure might not be a bad idea when using AI. However, we're disclosing tribunal secretaries now. The ICC has just celebrated 100 years last year. So I'm not sure that 100 years ago, tribunal secretary or legal assistance would have been disclosed. So we really have, we've passed it on to the arbitrator and said, if the parties are able to entrust an arbitrator or a tribunal with deciding on their case, they also need to entrust them with the decision of whether they believe, the tribunal, that disclosure is appropriate or not. However, we did make sure to say that there is a non-delegation, right? Does the arbitrator rely on AI to draft a ruling. And we've just decided from the get-go that that is something that should never happen. Most controversial things, the reason why tribunal secretaries were frowned upon after UCOS was exactly that. It was the delegation. So we said from the get-go that in our guidelines, our suggestion is that there is a non-delegation of decision-making responsibilities. We have specified decision-making responsibilities because we don't believe that using AI in drafting procedural history would really impede the hearings or the procedure per se. Again, it goes back to the arbitrator needing to make sure that everything is accurate, but it can really enhance the arbitration and become more cost efficient. And guideline 7 is again talking about tribunals, is the respect for due process. And the idea here is just that we know AI works, it exists. We understand that some arbitrators or in general people may be very curious to see, hey, if I ask ChatGPT, what should the outcome be of this case? What will it give me? And it's all fine. We trust that people are conscious of not disclosing confidential information and being very vague. But however, we do believe it is important to understand that AI-generated information outside the record should not be taken as a basis for rendering an award. And that talks about several things. It talks about hallucinations on the one end and also on outside sources. So, hey, what other cases have there been where XYZ was done? It's great, it works, but we do believe that as in every ruling, the tribunal should, in the end, base its decision or render an award based on information that has been rendered in that case. If we can move to the next slide, please. So the next steps, and that's that was one of the slides I was looking forward to. So we did come up with the initial draft of the guidelines. As mentioned, it was authored by 8 people, by me, Elizabeth Chan, Sophia Claude, Dimitri Evsev, Marta Garcia Bell, Orlando Cabrera, Soham Panchamiya, and Duncan Picard. I believe, I'm not that I believe this couldn't have been done just by me. These are bright individuals that have been able to help draft these guidelines in a magnificent way. We did open up the draft for commenting, and public consultation has been closed. So as of now, we're still in stage 2. So the input of seasoned practitioners and arbitrators has been closed. We are still awaiting consultation from institutions, and this will be process that will be ongoing. We opened it up for consultation for several reasons. First of all, we believe that as much as I'm convinced that every one of these bright individuals is outstanding, the more we get feedback from the actual community, the more it becomes credible and the more aspects we see that we maybe didn't see before. Now, that has been closed. We have now instated a guidelines review committee of highly esteemed practitioners, and we do anticipate the publication of the final AI guidelines in April 2024. This is the first time we actually mentioned this, so April 2024 is when we anticipate and envision the final guidelines to come out. So we're really looking forward to that. Now, with regards to institutions, it's going to be ongoing. We do invite every institution to give us their guidance or their comments on how to use these guidelines within their specific rules, and hope to get as many as possible. This will be an ongoing process. So let me see, Svetlana, is there one more slide? Or yeah. Okay, so the draft, as says here, can be downloaded on our website. As of now, if you Google AI guidelines, SVAMC, you will actually find them, which is great. And if there's any questions, please feel free to email me or the task force directly. Thank you, and it's always a pleasure to learn about what institutions and practitioners are doing, and hopefully these guidelines can help in those aspects. Thank you.
Thank you so much, Benjamin. We have about 10 minutes for some questions, answering at least some of the questions we've received, some of the many questions we've received. So let's give it a go. Svetlana, I think this first one is directed to you, and that is, did AAA ICDR consider asking arbitrators and counsel for potential uses of AI in addition to its employees? Any thoughts on that question?
Thanks, Jim. I answered it in the chat, but let me just answer it here as well really quickly. So we didn't specifically ask the arbitrators or the larger community because we wanted to make sure what we were piloting there was good data for, right? We wanted to develop a process using good data. And so that's why we did it internally first. We had control over the data, we could clean up the data, and we could make sure that our pilot programs worked. The AAA does have a technology council made up of over 40 individuals, internal and outside individuals. So they have also given us ideas. And as you know, being one of our arbitrators, Jim, many of our arbitrators just call us all the time to give us ideas. So we have received a ton of ideas, but we did not have a concerted effort to get it from the arbitrators, but we will in the future once we really sort of learn everything there is to learn from these pilot projects.
Thanks, Svetlana. The next question I'm going to direct to Benjamin with follow-up to Claire. It reads as follows: how may the use of AI impact the equality of arms aspect of due process, considering the possibility of uneven access to AI tools among different parties involved in the proceeding? So I think what this registrant is getting at is, should there be a concern about the fact that the parties in an arbitration may not have equal access to AI, and therefore one party will be advantaged? Benjamin, any thoughts on that?
Yes, so it's an interesting question, and I'm very happy you posed it. Funnily enough, I believe, or we believe, that access to AI is much cheaper than any other online directory or online research tool. So using AI in arbitration would actually technically be cheaper than using all of the other research tools such as Kluver, Westlaw, Thomson Reuters, etc. But quite frankly, this is kind of the big question that we've been dealing with for the last 20, 30 years. How does the small shop compete with the big law firms that have all these tools? And quite frankly, there's nothing we can really do. I don't believe there is an uneven access. Anybody can get them. It's a question of money. If anybody's willing to invest in that, then so be it. And it's the same if a small practitioner goes up against some big law firm that has 20 associates working on the research and an unlimited budget. Whether it's fair or not is really not for me to say or decide. It just is what it is. And quite frankly, using AI may be cheaper than using other research tools. But I'm curious to hear what Claire has to say about that.
Claire, any thoughts on this inequality of access issue?
I do think that there is an argument there. If one wants to make the argument, I think a tribunal will have to listen to it. I think two questions arise. How do you know, as counsel, let's assume counsel of the smaller firm with no budget to access AI tools, how do you know that the other side is using AI if there's no disclosure? I think you could get disclosure at the first CMC, at the first scheduling hearing. You could ask, you could try and see, I think we should discuss this. Should we talk about this? That's the first thing, you can ask. The other thing is this tool. By definition, if they can't access AI tools, so they won't be able to access those tools that detect the use of AI. But if there's a suspicion and is for some reason there is clearly a lack of balance, and that could have a prejudice, that could prejudice your side, then you might want to detect the use of AI and start a discussion based on that. That's all I can say.
Jim, if I can jump in and just add my small perspective to this, I think what Ben and Claire have said is really interesting. I come from it from a different perspective, though. Like, my thought is, the more generative AI is used, the more likely it's going to become more affordable for parties to use it, right? And so more people will have the opportunity to use it, almost leveling the playing field between those large firms and those smaller firms. So I guess I'm more optimistic for generative AI in the future, in that the greater use of it will actually make it more affordable for all.
Can I just add one more point? I think ultimately there might be an opposite reaction, where actually the use of humans will become more expensive than, AI powered council team tribunals. Ultimately, and I know some institutions are thinking about that. So we do have two kind of track rules, one track that's fast and cheap, lots of AI, and one that kind of most mainstream fast track, where we still have human doing the job to ensure fairness.
And if I may just quickly add a 30-second response. I mean, our guideline 3 talking about the disclosure of AI comes in very handy, where parties could technically decide that no AI shall be used. But as mentioned, I'm really sure that AI is cheaper than other resources, and quite frankly, I would pose the question the same way as having a big research team of 20 associates. What is there really something you can do? And I just don't think there is. It's time effective. AI is a little more time effective, but in the end, there is a huge budget. You got to invest in something that is time effective to that end. So, yeah.
Very good. Okay. All right. We have another interesting question. I think we have 3 minutes or so. This involves the use of confidential information, the opposing party's confidential information that has been disclosed pursuant to protective order. And the question is, to what extent is the use of AI resources by a law firm, to what extent does this raise any concerns if the law firm uses the AI for protective or information covered by a protective order, confidential information, in particular at the close of the proceeding, which typically in many confidential or protective orders require the destruction of confidential information? How would that be dealt with if it's already part of the AI tool and the AI learning experience? So I'm not sure. Anyone want to volunteer for that question?
Well, I think it would be based on the terms, which terms you received information, what are the terms of the protective orders, what can you do with the data, and just checking those terms before proceeding with incorporating the data into an AI tool, because that's right. Once it's there, it's difficult to take it back.
Well, could a party prevent the use of its confidential information by the opposing party to train an internal AI tool? I suppose that could be an issue raised by the parties with the tribunal.
If the AI tool is only used for that specific arbitration, I think it would be difficult to oppose to that. One can try. If the information can be used, for AI tools used in other matters, that I think there is a clear problem there.
Very good. So we have one last question, and I'm going to exercise my moderator's prerogative to try to answer it. The question is, in what other ways can AI use to assist the parties in their counsel and arbitrations? Two creative possibilities have come across my desk. One is text to video. Some of you may have seen articles featuring the video of woolly mammoths thundering through the meadow that was created by a text. This is going to open up all kinds of possibilities for demonstrative videos to be used during arbitration. Another is first drafts of witness statements, in which an AI tool actually listens to the witness interview and on that basis generates witness statements. Now, this, of course, raises all sorts of interesting questions about privilege and confidentiality, but it just underlines the exciting new world that AI is making possible for all of us. So we have reached our 1-hour mark, and we must reluctantly conclude on behalf of Mayor Brown's Silicon Valley Arbitration and Mediation Center and all the panelists. I Thank you for joining us. You can obtain a video download from a link that I think has been circulated to all the registrants. I'm not sure that we covered the code word that you need for the CLE form, which is arbitration 20. And if any of you have any questions, please don't hesitate to contact any of us by email or otherwise. Thank you very much.
Thank you.
You.
Thank you all for joining.